Okay, so without further ado, I'd like to introduce Natalie to the stage. And on the early agenda, Matt Smith was going to be here presenting for K&L Gates, but he's out of the country. So is volunteer the right word?
Yeah, volunteer is definitely the right word. Thanks very much, Glenn. So like Glenn said, Matt was meant to present with me today, but we did have a look at some of the legal challenges that K&L Gates are advising our clients on. And we came up with a list of 7 topics, which I'll talk through today. We're starting off with going nuclear. How is NEC being used for nuclear projects? Then looking at NEC and AI. Then how is X29 doing? Fourthly, the NEC and inflation. Then we turn to disputes, which Matt gave an introduction on already, which is great. 6, the Building Safety Act, and 7, NEC's approach to delay damages. So it was really interesting listening to Matt's talk because there's obviously, we're dealing with a lot of the same issues in the industry, whether you're coming at it from the commercial perspective or the legal perspective. So starting with our first topic, going nuclear, how is NEC being used for nuclear projects? So nuclear is traditionally a bespoke contract, but there has been a growing trend looking at, is there a standard form that suits nuclear projects? And it looks like NEC might be the way to go. We're moving away from this traditional full wrap EPC approach to nuclear contracts because these are such high risk, high value projects. There's not a single EPC contractor out there who wants to take the whole risk of decommissioning or building a small modular reactor. What we're seeing is we're bringing different specialisms together, whether you have the supplier of the nuclear island, and then you also have your contractor. So perhaps that full wrap EPC is not the way to do it, and we're looking at something like NEC 3, NEC 4 for nuclear projects, both in the UK and overseas. And at the heart of NEC is this collaboration, flexibility, and transparency. Those are all key attributes that we also need to see in nuclear projects because of the risks. And what NEC brings is more of a balanced risk profile. For example, we have NEC option C with a target price that's adjustable for compensation events. To come up with that price, what if bidders and the clients work together on an open book basis to give a price estimate for what the scope of works would actually cost, rather than a client putting it out for tender saying and leaving it to the competition. In that target price method, we have a pain gain share mechanism where cost overruns and cost savings are shared between the parties. That could be looking quite attractive to nuclear projects. There are a few other reasons why NEC is suitable for nuclear projects. So inbuilt risk management tools in NEC, we have the early warning system, we have risk register mechanisms that align quite well with the risk-heavy and uncertain nature of nuclear decommissioning and other nuclear projects. Transparency and accountability. Under NEC, contractors need to give regular program updates, and there's defined compensation event procedures, which gives a bit more clarity to the parties about what happens when something unexpected happens in the project. So that ensures for both the Nuclear Decommissioning Authority and government entities that they have some visibility over public funds. Flexibility, NEC has a range of options. We're looking at these modular options, A to F. That allows a bit more of a tailored approach to nuclear projects, which often are unique, or we're doing something that hasn't been done before. So you might also want a contract that is bespoke but still standard form. The collaboration mandate, which I mentioned earlier, the NEC obligation to act in a spirit of mutual trust and cooperation, that supports some of these long-term partnering arrangements in nuclear contracts. Nuclear contracts are not, 6-month, 12-month builds. They're long projects. And finally, schedule control. There's quite detailed programming requirements in NEC, which you might not see in other standard forms, which also are useful for nuclear projects, whether that's dismantling or decommissioning activities or building a SMR. So we are seeing NEC already being used in the UK for nuclear construction and decommissioning projects. Hinkley Point C is an example, and they've just announced Sizewell C is going in the direction of Hinkley Point C. And by that, we mean they're probably using NEC as well. There is the decommissioning at Sellafield. That's an outcomes-based NEC 4 contract suite that's used across 25 projects with a project value of £7 billion. So we're looking at fairly large-scale nuclear projects using NEC. And the reason being, it's collaborative, there's a focus on the community benefit and the sustainability of these decommissioning projects. We also have decommissioning at Magnox nuclear power stations. The suite of NEC 3 contracts are being used there. The benefit being this standardization of procurement and project management and a streamlining of supply chain facilitated by the approach that NEC takes. And finally, the Great British Nuclear, they are looking at NEC to underpin their SMR projects in the UK as well, and they're currently in the technology provider selection process. So another example of nuclear using NEC. Moving on to something slightly different is NEC and AI. So the question we're looking at is, can smart contracts and digital decision-making change construction law and projects? I think it's a resounding yes. But we're now looking at how exactly are we incorporating smart contracts into NEC and in the construction industry generally. The definition's up there on what a smart contract is according to the Law Commission. And there seems to be a couple of different models, and I see it as kind of a spectrum. So at one end of a smart contract, you have a natural language contract, and then you might be looking to automate some of those tasks using code. And at the other end of the spectrum, we have a contract recorded solely in code. I personally haven't seen what that looks like yet, and we're probably leaning towards some kind of hybrid model, and that's how the future is looking for NEC and AI. So we have some provisions that are in code, some are in natural language. And the benefits of providing those provisions in code is that they can then be stored in blockchain and you can automate certain processes. So these kind of smart contract elements may find a fit with NEC, which is more flexible, which is more adaptable and meant to be more user-friendly than some of the other standard forms. The Law Commission has already said that the framework is there for smart contracts. We don't need any massive legislative changes in the UK to incorporate smart contracts into our legal system. The reason being, common law already provides that kind of flexibility. What we do need to understand, though, is smart contracts are going to give rise to quite novel legal issues. We need to find ways to build out smart legal contracts, to develop things like model clauses, to develop an established practice, to really gain the benefit of smart contracts before they're in wider use. What we are thinking at the moment, though, is smart contracts at the moment are really helpful when it's a quite standard mechanism. There's less independence and judgment required. So, for example, there's a couple of examples on the screen. Payment escrow. Can funds be held until agreed upon conditions are met? And then instead of having someone authorize the release of those funds, could they be released automatically if that code is already written in the blockchain? There's something like progress tracking. We've had a debate about this internally because on one hand, a contractor should hit certain milestones and those payments should be released. On the other, when you hit certain milestones, a project manager as a human, is looking at that personally and saying, has the contractor met those milestones? Has the contractor provided all the sufficient information to prove it's met those milestones? And then it will release payment. So there is still a bit of a subjective element there. The other examples we're thinking of are quality assurance, contract admin, so distributing contracts, doing some of that, taking some of that administrative burden off of the project manager, and then supply chain management. If we've got a supply contract, should payments just be automatically released on delivery once proof of delivery is being provided? Then there's the question of some of the more ambitious uses of smart contracts, or how are we going to incorporate smart contracts in some of these automated processes in the future? So there's some talk of automation of the DRP provisions. So that would mean a contractor issues an NCE, a project manager's looked at it, has rejected the NCE, and at that stage, if you have a smart contract, there's potential that a dispute is immediately triggered. That means the parties are dealing with that as soon as the rejection happens. At the moment, it's looking like that could be a step too far. As we know, triggering disputes can be expensive. Do we want to trigger them, 1 month into the project when an NCE has been rejected? Or do we want to deal with this on a more commercial basis? Because at the end of the day, your employer, contractor, subcontractor, they're all commercially minded. They might not want to trigger a dispute under a set of set conditions. And there might be a more human element involved as well. The same thing with calling performance bonds. It's quite a drastic step for an employer or a contractor to take to pull a performance bond just because the conditions have been met in the contract. That you might want to wait to the later stage, and you might not want AI to be making that decision for you. So it is looking like it's more of those mechanistic processes where AI is more helpful. And the benefits of that is there's less of an administrative burden on the project managers. There could be more transparency, especially if your elements of the contract that are in code are stored in blockchain. And there could be a streamlining of processes. At the end of the day, your project management fees could be reduced. But then you also have to consider the downsides, which I've just discussed, like early trigger of disputes. So it's looking like we probably still do need project managers. We are going to need... I'm sure many of you in the room will be glad to know. We are still going to need someone with the experience in the construction industry to assess mitigation measures. It's difficult to see how AI can do that, for example, or to assess concurrency. It's also worth, though, at this stage, thinking of some of the legal issues that could come up before we start embracing smart contracts. So let's have a think about, for example, contract formation. If your contract's in code, is it technically a contract that's in writing and signed? Perhaps not. Some other things like order of priority provisions and disputes regarding interpretation of the contract language. So what does language mean to a reasonable person? If your provision in the contract is in code, how do you interpret that as a reasonable person? Does that mean we need some kind of reasonable coder test? Or data protection and IP, which is obviously an issue in smart contracts. We might need some new Z clauses around privacy laws. What happens, for example, if there's a data breach? Does that need to be a new compensation event that we're thinking about? Because at this stage, we're thinking of storing and sharing our data on blockchain networks, which is not something we've done before. Then another one up there, which I thought was interesting, is how to establish breach of contract where contractual obligations are defined in code. So it's looking like with AI, there's definitely a use for it, and we're definitely going to see it more incorporated into contracts, including NEC contracts, because of the nature of how NEC is set up. But there's still, I think, a bit more work to be done before we can progress that further. Jumping on to our next topic, how is X29 doing? I think a couple of years ago, one of the partners at K&L Gates gave a talk on X29 when it was first introduced, and we thought it'd be helpful to take a look back and see what's actually happening with it. So just as a quick recap, under X29, the client states the climate change requirements in the scope. The contractor then sets out a plan for achieving the CCRs. There are financial incentives potentially included, also potentially financial disincentives through the performance table. And then there's an obligation on the contractor to collaborate with climate change partners. So where is X29 now, though? We are seeing X29 in some of these big, sophisticated contracts, big infrastructure projects. It aligns with the government's net zero plan, so potentially public sector contracts. We're not really seeing them in some of the smaller, less complex projects. So it seems we're still waiting for the potential for X29 to be realised. There's a couple of reasons for that. In X29, it could pose quite a heavy burden on the contractor to meet all these climate change requirements, especially if you have things like a performance table. The market might not be ready for a general climate change provision in all construction contracts, but it could be of benefit when there's these bigger infrastructure contracts. It probably also works best when the CCRs are developed between the client and the contractor rather than being set at tender stage and not be able to be negotiated. That means a contractor can plan for it, can price for it, and can understand whether it's reasonable or feasible to comply with climate change requirements. We are also seeing a reduced or streamlined approach to X29 being taken. That could mean, for example, not including the performance table at all. So there's these requirements. It's a breach if you don't meet the CCRs, but maybe there's no deduction for not meeting those CCRs, or maybe there's no bonus payment, which can make it a little bit more simpler to incorporate into NEC. So the risk of overloading the contractor is something I just mentioned. There are certain obligations the contractor has to take with CCRs in terms of they've got to give things like early warning notices if it will impact the achievement of the CCR. It forms part of the scope. So if a contractor does not comply with the climate change requirements, it could be a breach. And if the failure relates to the works, then it's a defect, capital D, that must be corrected. So how do we deal with this issue? One example is developing the CCR jointly, which I just mentioned. There's also thinking of, should we be linking the climate change requirements to industry standards and seeking to use external benchmarks to determine whether the CCR has been achieved? That might create more of a standardization around climate change requirements instead of a pick and choose method. For some of those could be, for example, the Built Environment Carbon Database to measure carbon reductions or biodiversity net gain. So the performance table is always a tricky one. It can be used in a variety of ways. It can be positive incentives and it can be negative incentives. Or it could just be used to measure and record the performance achieved. Ideally, what we're thinking is that positive incentives are the way to go. Negative incentives start to create issues and start to create that burden on the contractor, where it could simply be you can't price for climate change requirements and a contractor doesn't want to enter into a contract that's including this option. There's also the need to create some certainty over how do we measure those climate change requirements have been met. The last one being there's also an administrative burden around administering something like a performance table. That's what we're seeing on X29 at the moment. Our next topic being NEC and inflation. So does the contract's cost mechanism work in a volatile economy? The default in NEC is that contractor takes the risk of inflation. That's fine during periods of inflation, of low inflation, where the bidder's already made a small allowance for inflation, and that's okay. But what we've been seeing in the last couple of years is periods of high inflation, maybe not across all construction materials, but some key ones like copper have gone through the roof, and it's not measurable against things like CPI anymore. So we have option X1, which is client takes the risk of inflation. How we measure if that is working might depend on which indice we're choosing. Do we need more sophisticated construction industry indices? Because the inflation relating to construction materials is just simply outpacing general inflation. So maybe CPI is not the way to go. Each project is also different. So should X1 and the price adjustment, should that be prepared in consultation with bidders instead of just being set by the client? Would that reduce disputes later on? So rising costs is something that contractors are facing. We know that in the construction industry. So it could mean that if we have a fixed price contract X1, contractors are really struggling. Should we be looking at some of these target contract approaches and how they're approaching inflationary risk to distribute it between the parties? These are all questions that really need to be answered, at the beginning of the project to decide which is the best mechanism for this particular project in terms of inflation. So what we'd want to avoid is leading to disputes. NEC is meant to be collaborative. It's got really good dispute resolution procedures, but at the same time, NEC disputes are still ending up in court. And we thought we'd have a look at why that's happening. So the 2023 report showed that level of compliance with adjudication decisions is high. That could mean the dispute resolution procedures, not just in NEC, but more broadly, they're actually working. At the same time, and this is probably a lawyer answer, it can be a good thing when NEC disputes end up in court. We get some really good clarity on decisions. For example, we had the Northern Ireland Housing Executive and Healthy Buildings case recently that applied, NEC 3 clause 10.1 to the compensation event provisions. And we had a decision around the implied duty of good faith that we didn't really understand. We didn't really have court guidance on before. That being said, obviously, when you end up in court, whether it's just because of a final decision, you've decided to go that extra step to take it to a court or tribunal, it is costly, it is time consuming. The other reason you end up in court is you have an adjudication determination, but one party is unhappy with that determination and decides to resist enforcement. The usual grounds being, lack of jurisdiction, breach of natural justice, and I'll get into that a little bit further. However, the Adjudication Society has noted that the courts are taking pro-enforcement approaches to adjudications. So the 2023 Construction Adjudication Report found that the TCC enforced 77% of adjudication decisions, either in part or in full. For example, the case I've put up there on the screen, UK Grid Solutions and Scottish Hydroelectrical Transmission. The employer was unsuccessful and went to court to try and overturn this decision. The reason the employer said the decision should be overturned was that the adjudicator had failed to address a material line of defense that the employer had run. The courts looked at that and went, an adjudicator doesn't need to expressly deal with every single line of argument put before him. He needs to provide a path to his decision. So he needs to consider all of the relevant defenses and claims that led him to his decision. That's just one example of the approach courts are taking these days on adjudication determinations. The construction adjudication report, I think this is the same one from King's College that Matt mentioned. I think this graph is actually from the 2024 version. So it looked at what are the grounds for resisting enforcement of adjudication decisions. Mostly lack of jurisdiction. There's some areas in breach of natural justice and occasionally a combination of both. We also have this other category. It wasn't exactly clear from the report what that could be. Based on our experience, it could be things like the adjudicator has made a manifest error. He's just got it so wrong, and you often, in that case, combine, Part 8 claims with Part 7 claims, and both defend the enforcement of the adjudication decision and also get an answer on a discrete legal issue under your Part 8 claim. At the same time, lack of jurisdiction is still the most common ground for declining enforcement. As you'll see there, it's 10% of the success rate of grounds for refusing enforcement of adjudication decision is being attributed to lack of jurisdiction. What we don't know, however, is how many potential disputes are being resolved before the more formal dispute resolution stages. We're really never going to know that because we only have reported decisions on adjudications on what's ending up in court. So are NEC's proactive approaches to managing risk and collaborative working, are they actually working? There does seem to be a trend towards increasing adjudications, and you can see that when you compare the 2023 construction adjudication report to the 2024 version. There's approximately a 9% increase in adjudications just during that 1 year. So what are the reasons we are finding that disputes are escalating to adjudication and escalating to court, or disputing or escalating to this enforcement challenge stage? The claims being referred to adjudication, they're becoming more high value and more complex. So if you have a higher stakes claim, maybe you don't want to just stop it at the adjudication stage if you are really unhappy with your decision. Maybe the value of the claim warrants you progressing that further. There are also projects becoming more complex. So if you have really technical issues, maybe an adjudicator wasn't equipped to deal with those issues. Matt talked about how an adjudicator could be receiving 4 different expert reports or 8 different witness statements. Maybe they're not all experts in quantum delay and the particular defects that you found in your project, and an adjudicator is not quite the best fit to make a decision on that dispute. That could be why it's being resolved. An adjudication process is also short. It's meant to be a 28-day process. So maybe that's not the right forum, for example, for a final account dispute. One option to kind of reduce the amount of NEC disputes that are ending up in court is the idea of a dispute avoidance board, which is becoming more popular. So there's a standard dispute avoidance board option that can be incorporated. Another thing we're also seeing, which is very interesting, is a standing dispute avoidance board. You tend to only see that on your higher value projects because it means the parties or the client has to invest in paying a standing dispute avoidance board to be kept apprised of the project. But it could be really useful for resolving disputes as and when they arise, instead of waiting till the end and ending up with a big final account dispute, which is 1, not suitable for an adjudicator, and so 2, you're ending up in court or in front of a tribunal anyway. So weighing up those costs, I'll admit it, as a lawyer, legal costs are expensive. So maybe you want to invest the money in those standing dispute avoidance boards rather than spending a lot of money in arbitration at the end of the day or in court. Next topic being the Building Safety Act, which is also something that Matt's mentioned as well. So Building Safety Act, we all know, it's a really important piece of legislation. It was incorporated into the construction playbook. It's not expressly mentioned in NEC, and we are not sure whether it will be expressly incorporated into NEC. JCT did it, and it was actually criticised for not addressing it enough. For example, it included the new duty holder regime provisions, but it didn't address the higher risk building provisions. But why do we think it won't be included in NEC? We're thinking that NEC, through things like Clause 27.4, already addresses compliance with health and safety requirements, or compliance with legislative requirements under the statutory requirements Z clauses, which are often included. Maybe also the Building Safety Act will be just included on a project-by-project basis in the scope of works, and that could be enough. Or there is also an argument for including the BSA as an Option X clause. That means you have something that addresses both the health and safety requirements and the statutory requirements. So maybe this is on the books for, again, NEC 5. And my last topic of the day is NEC's approaches to delay damages. So starting off with the JCT, that includes default liquidated damages provisions. All the parties really have to do, all a contract administrator has to do is insert the rate in the contract particulars, and you have an inbuilt delay damages provision. In NEC, we have Option X7, which is an optional provision. The majority of the time, Option X7 is being selected. So does that mean we should be including X7 as a core clause? We saw it in the assignment clause when it went from a Z clause to a core clause between NEC 3 and NEC 4. We're thinking this could be a good option because when you structure delay damages as an optional clause, you run the risk, firstly, of it being unintentionally left out. The parties intended to have a rate for liquidated damages, they forgot to include X7, and then you're left with the situation where general damages need to be proven instead. It doesn't necessarily benefit either party. It really depends on the project. So that's why we do have quite standard liquidated damages clause, because it gives clarity to both sides. There's also the potential that X7 may be not incorporated effectively. For example, have you included Option X7, but then you haven't included the rate in the contract data? So could you be in the same situation? X7's not enforceable, and you're ending up having to prove general damages anyway. It is more of a robust clause now than it previously was. It was amended in 2020 in response to the decision in Triple Point. So we now know that delay damages cease upon termination. We also know that post-termination, any further delay-related costs, they're treated as general damages and must be proven. So with that robustness built in now, could this be something that's on the agenda for NEC 5? Or should we just for now leave it on the pick and mix options in secondary options and let the parties choose to include X7 or not? I'll leave you with that question to ponder and hand it back to Glenn.